Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. It is Tuesday, which means it is Tuesday Night Live. Here we go. Now, for those who have not joined us before, my name is Scott Reich. I am a practicing criminal defense attorney. Have been doing that for going on 30 years now. And we've been doing our little blog for, 7 years or so right now. And, it's been a lot of fun. It's been a lot of fun, met a lot of interesting people, and we have tried to provide you with some value, trying to give it to you straight, fact-driven, unbiased analysis based upon the facts and the law, and I think we do a pretty good job of that. One of the reasons why we started this podcast was to basically try to be able to explain things in greater detail that you didn't normally get when it came to the evening news or, some tabloid somewhere trying to explain something. I think we've tried to do that for you. Like I said, we try to give you the truth, the facts, and an unbiased analysis of what's taking place. I always find it interesting when people on both sides of a particular case say that I am in favor of the defendant, or you're so against the defendant. Must mean we're calling it right down the middle if that's the way people perceive what's taking place. And that's what we try to do. I have no dog in this fight. I am of the mindset, and I appreciate each and every one of you for tuning in. I appreciate and understand that there are other things that you could be doing with your time, and the fact that you take the time to join me, it is a humbling experience for that to take place. I assure you, it's humbling when if we miss a day or two because I'm in trial or something like that going on, and then literally people will call the office and wondering if I'm okay. Is Scott sick? Something going on. He hasn't had a show in a couple of days or something. So that's humbling. Okay. Or people say, oh my God, I can't believe you're not doing a show. Who am I going to make dinner with? Because we put out our shows generally in the later afternoon, and people say, I cook dinner to you. I listen to you every night for dinner. So, like I said, we appreciate that. We really do. So thank you for allowing us into your living room, bedrooms, office, studies, what have you, wherever you watch this. Like I said, it is truly humbling that people would take the time to listen to, just a little street lawyer out there representing people accused of crime. But I would like to say that, we have been doing this for a while. I think we're pretty good at it. And we know, literally every type of case that we have talked about, done it. Okay. And I'm not going to throw stones at other people out there on YouTube, but there's lots of people, and there's lots of people with a lot more subscribers than I have, that have never been in a criminal courtroom or tried a case or only done a handful of cases. And most of them have never tried a murder case. And not only have I tried a lot of murder cases, I'm up to eight not guilty, out the door, all counts, not, oh, you're charged with murder and you're get convicted of second-degree murder or felony murder. No, 8 not guilties on first-degree murders, walking your client out the door in my career. Some people don't do 8 homicide trials in their life, let alone 8 not guilties. So, not trying to say, people got to make a living. People got to do what they got to do. YouTube is not my full-time career yet, but we're working on it. But it's like anything. If you go to hire a lawyer, who are you going to go hire? You're going to go hire the most experienced lawyer that you can afford. And since we bring it to you for free here, you should be watching us every single day. So, just something to think about. And I love met lots of those other lawyers out there. I'm not throwing stones. I am not. But it just strikes me as funny sometimes, these people that strike themselves as, they were a prosecutor, they were a defense attorney, and you know, you kind of do a little research on them, and they've almost done nothing. They've been, you know, YouTubing longer than they've been practicing law. I just find that interesting. Like I said, every kind of case that we talk about, like I said, I've done it. You know, murders for hire. We've done them all. You name it. The worst imaginable cases that you can imagine, we've done it. Okay. And so when I'm talking to you, it's not to brag. I'm just saying, speaking from experience, this is how this thing is going to play out. All right. So let's get there. Let's, you know, had a little time for some people to join us. So let's go ahead and see what we're going to talk about today. Two things I'd like to talk about. One, Bryan Kohberger. Okay. And we're going to do this in reverse order here. Bryan Kohberger. Why? Because there's been some new stuff released just this evening, right before we go live. And I love when we break news. I think there's some significant news in the Bryan Kohberger matter. So we got that. And then, of course, we have the Lori Vallow case. I almost get this close to thinking I'm getting to feeling a little sorry for Lori Vallow. And then I remember she's representing herself. And I cannot wait to see her in court. Now, maybe she will exceed my expectations. And maybe she'll do a fine job. I mean, she sat through, you know, a homicide trial. I'm sure she's read the transcript of her husband's homicide trial where, you know, he was convicted of killing his now deceased wife and her two children. So maybe she's been around the block a couple of times, right? I mean, in all honesty, could she really have done that much worse than her attorneys in Idaho? I mean, she spared herself the death penalty because the judge dismissed that the death penalty sentencing aggravator because the prosecution couldn't get their act together. And she's like, no, I'm not waiving speedy trial, which is kind of sad and pathetic in its own little way that a woman that just was found to be not mentally competent was able to outmaneuver some of those lawyers, not only for her defense team, but the prosecution, and got the death penalty dismissed. You know, it's kind of like that scene from Legally Blonde, like it's difficult or something, right? That's what she's probably saying. So she had a pretrial conference today, and things didn't go exactly as, you know, Lori would have liked them to have gone. First, she wanted to introduce, you know, the various statements of Alex Cox, but he's dead. He's dead and not subject to cross-examination. That is hearsay. When the judge said, remember, ladies and gentlemen, hearsay, an out-of-court statement made by another, offered for the truth of the matter asserted. Well, if it's not for the truth, why would we be offering it in the first place, right? That's always my response when DA said, well, judge, it's not being offered for the truth of the matter asserted. Well, then why is it relevant, right? Just ask the question. Did you have, without saying what was said, did you have a conversation with person A? Yes, we did. Without saying the nature of the conversation of what was discussed, what did you do after that conversation? Oh, I left and went and spoke with this particular person, right? Well, you're normally prosecutors try to bring, and did you speak with so-and-so? Yes, I did. And what did they say? Objection, hearsay. Your Honor, it's not being for the truth matter asserted, only that the conversation took place. Well, the example I gave is how you get around it. But most judges are like, oh, it doesn't matter. It's just peripheral. Let's just do it, right? No. So yeah, that's, you know, anyway. So she doesn't get to bring in her dead husband's statements because he's dead. Now, obviously, that's kind of a problem for the prosecution as well, because it would be a hearsay statement. And you don't get to benefit if you're accused of slaying somebody to get the benefit of their statement being introduced. But the prosecution also has that problem as well. You still have to have an evidentiary foundation, an evidentiary rule to get in statements of a dead guy. And if they are not going to show up for trial, obviously, and be subject to cross-examination, it doesn't matter, you know, it doesn't come in. So Lori's a little disappointed by that. The judge says, asks her, why would I allow this in? Well, it's not being offered the truth of the matter asserted. Well, then why would we allow it in if it's not the truth? So remember that, ladies and gentlemen. Here's hearsay. Everybody asks, you hear people say, oh man, that's a hearsay statement. Well, I mean, technically anything anybody says is a hearsay statement because it's only not hearsay if you are in court under oath, subject to cross-examination. Would it be a non-hearsay statement? And the speaker of the statement cannot testify as to what somebody else said. Now, of course, there are certain exceptions to that, but that's the whole point. You have to bring the person into court to testify as to what they saw, what they heard, what they smelled, all their observations. Otherwise, it's hearsay and it's not admitted. Okay. So when people say that's a hearsay statement, it's a hearsay statement. Well, it won't be when they come to court and say that you are the bad guy that did it. Okay. So anyway, Lori Vallow in court today didn't go as she has hoped. And she also wants to keep the cameras out of the courtroom. She feels as though the people that have been following this case, court TV, that they've been very unfair to her, that they're exploiting her name, image, and likeness, so to speak, for the benefit of the viewing audience. Anyway, the judge said, Miss Vallow, I will issue an order. There'll probably only going to be one camera in the courtroom. They're not going to be able to zoom in on her notes, because she's going to be over there taking notes, writing everything down in court. And if any of you saw her little interview that she did with, was it NBC or something? The truth is coming out. I was a little disappointed in the whole thing. It was just more of a rehash and, she's going to be vindicated, all that stuff. Not particularly, I get it. They were looking for the exclusive. They got it, but I don't think it was particularly earth shattering one way or the other. All right. So Lori Vallow, it's going to be a train wreck. And like I said, maybe I'll be pleasantly surprised and think, wow, she's a very good attorney. Or non-attorney acting as an attorney, which people can do. I'm not, nobody, just because you went to law school doesn't mean that you're a good attorney. I've seen lots of dad attorneys that went to law school. I have had paralegals over the years that could outmaneuver many an attorney, could draft motions better than an attorney. So please don't understand. I'm not trying to say that attorneys have the end all to be all when it comes to all of these, courtroom procedures. But what attorneys do have is a little bit of an understanding of the rules of evidence. And normally we've learned those rules of evidence the hard way when either A, we couldn't get something in, or B, it was explained to us why the evidence was coming in. All right. So now the other thing I want to talk about is Bryan Kohberger. All right. And maybe somebody can tell me why on my computer. I don't know why. Maybe something's got into my system, but it keeps wanting to say that Speechify should be on my computer all the time. And I don't want it to be on my computer at all. Quit popping up. You're annoying me. Speechify. I don't even know what Speechify is. Anyway, we'll deal with that. One more thing before we get to Bryan Kohberger. The notices that Lori Vallow filed in her case. The defense's noticed the following: insufficiency of the state's evidence. I'm assuming that's just a general denial, right? The prosecution is going to be unable to meet their burden of proof, which is the highest form of proof known in the law, proof beyond a reasonable doubt, unanimously to a jury of 12 people, right? With legal and competent evidence, means evidence that actually comes in a courtroom under a specific rule of evidence. Okay. Now, she also listed self-defense, defense of others, and third party is at fault, which would be really good if, for example, you were in a, I don't know, a tort action, right? She's charged with conspiracy. We talked about this today a little bit in our regular show that we put out. A conspiracy, ladies and gentlemen. Come on. Who can do, mention what a conspiracy is? Really simple. All right. We'll wait for any answers, but it's an agreement between two or more people to commit an illegal act. That's a conspiracy. You need at least two to have a conspiracy. It can be three. You don't even have to know all the participants in that conspiracy, and you can be held responsible for the end result of the conspiracy. So anyway, Lori Vallow has listed as her possible defense self-defense. So let me just try to work my way through this. She's charged with conspiracy to commit murder. And the charge is that she conspired, an agreement between two or more people, between her and her now deceased brother, Alex Cox, to kill her number 4 husband, Charles Vallow. So the agreement is one, there was no conspiracy, because no one is saying that she pulled the trigger against Charles Vallow. I mean, the boyfriend or the brother did it. The brother did it, right? Alex Cox. But who's going to testify to self-defense for Alex Cox? Alex Cox is not there. Remember, his statements don't come in. So what are the police going to get to testify to? Well, we were called to this house. And we found Mr. Vallow deceased, there in the house. Okay. They collect the phones, they do what they need to do, right? They get the GPS data, etc. Then they come across these text messages, he's a bad man, dark side, all that kind of stuff. Is it just, brother and sister chatting about, the ex-husband that they want to get rid of? Or is it something a little more nefarious? Was it actually an agreement between two or more people to commit an illegal act, i.e. murder? So the defense is there was no conspiracy. And I guess you're going to say if there was a conspiracy, it was in self-defense. So therefore, no, you can't do that. It should be general denial. There was no conspiracy. Alex Cox acted alone. That's the defense to conspiracy. Either the act didn't take place, there was no conspiracy, and you can have, I just don't see where they're trying to come up with defense of others. If Alex Cox, if you could have a defense of others as to Alex Cox, he was defending who from whom? That doesn't make any sense. Yep. Generally conspiracy defense is I didn't do it, or there was no illegal act. I guess you're saying there's no illegal act because it was self-defense, but I'm not sure how she's going to prove self-defense since none of Charles Vallow's statements are coming in. The only exception to that would be under Rule 801D2E, which would be a statement of a co-conspirator made in furtherance of a conspiracy. And so the prosecution would be the one offering that particular evidence. And they would first have to establish that there was, by a preponderance of the evidence, a conspiracy. The statement being offered and by whom would have to be in furtherance of the conspiracy, not after the fact, right? In furtherance of it. Hey, we should go whack the guy. Good. You go get the instrumentality to whack the guy, right? Get the gun, get the hammer, do whatever, get the bat. That's what we're going to do, right? Let me just see here. Okay. Oh, the job never ends, ladies and gentlemen. And that job never ends. Literally, looks like client is literally probably being arrested as we speak at this very moment. Let's see here. Let me go back here because now I scrolled up. Sorry, this is welcome to my life. It never ends, ladies and gentlemen. Here I am trying to talk to you about this particular case. Anyway, we'll have to wait until the top of the hour, I guess. I'll just have to wait. Anywho, so that's going to be the defense. Okay, that's going to be the defense. There was no conspiracy. Whatever happened, Alex Cox acted alone. I'm not sure how she's going to get self-defense in there, but I guess the defense is whatever took place was justified under the law. But the only way you get to self-defense is you have to have Alex Cox's statement come in to say it was self-defense. And, well, he's dead. So that would be hearsay. So that's not coming in. Any statements Alex Cox made that was in furtherance of the conspiracy, I guess you could try to argue if you were the prosecution that was in furtherance of the conspiracy to cover up the conspiracy. But Lori Vallow would not be allowed to introduce that evidence because that would basically be self-serving hearsay. So I don't think that's going to come in either. Lori Vallow is basically, I mean, who knows? She may surprise us all. Maybe the jury will do that. Yeah, we're just going to have to wait and see for sure. That's going to be the big one. All right. The next thing, Bryan Kohberger. All right. Some new motions have hit this evening, and a couple of them not so interesting at all. State's response to defendant's motion for leave to file additional expert witness disclosures. Basically, the state says the state believes it's in the interest of the parties and the court for there to be a reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. The state does, however, anticipate the defendant's allegation regarding the state's lack of any real disclosure in part, the defendant's motion at page 2, as the court can see from the extensive disclosures by the state, this allegation by the defendant is anything but accurate. Anyway, the state does not oppose the granting leave for additional expert witness disclosures. That's nice of them, right? Go ahead and do it because we want the truth to come out. State's response to the defendant's motion in limine 8 regarding unnoticed 404B evidence comes now the state of Idaho by and through Latah County prosecuting attorney, and in response to the defendant's motion in limine number 8, unnoticed 404B evidence filed February 24th, 2025, advises court and counsel that the state intends to comply with the application Idaho rules of evidence in regards to any proposed Idaho rules of evidence 404B evidence. So they'll get to it when they get to it, and it'll be in compliance with the rules. Defense, get over it. Let's see here. State's response, defendant's motion in limine regarding improper expert opinion testimony. The state's disclosure comes now. The state of Idaho. In the Latah County prosecutor response, the defendant's motion in limine number 10. Improper expert opinion testimony, referring to Middleman, filed February 24th, as follows. The state's disclosure regarding Dr. Middleman was in response and rebuttal to the defendant's listing Lee Larkin and Daniel Hellwig as expert witnesses in regards to the IgG, right? The investigative genetic genealogy matters, and demonstrates his superior quantifications by education, research, and direct experience with investigative genetic genealogy. However, here's the big news, ladies and gentlemen. However, now that the defendant has indicated that he will no longer seek to offer evidence related to IgG, See defendant's February 24th, 2025 motion in limine number 11, exclude the evidence, including not calling Miss Larkin or Mr. Hellwig. The state has no current intentions of calling Dr. Middleman to testify in rebuttal. The state notes that its February 24th, 2025 state's motion in limine regarding investigative genetic genealogy, seeking, among other things, an order in limine describing the extent to which the parties can refer at trial to investigative genetic genealogy used in this case, is still pending. But in light of the defendant's position that he will not be raising any issues related to IgG evidence, the state is willing to agree and now gives notice to court and counsel that it will only seek to introduce evidence testimony that law enforcement received a tip without mention of the source or substance of the tip, and that law enforcement then followed up and identified the defendant. See state's response to the defendant's motion in limine, excluding IgG evidence. So there you go. That's the big news in the Bryan Kohberger matter, ladies and gentlemen. The defense isn't going to get into the whole IgG issue as it relates to the DNA evidence. Why is that significant? They're basically conceding that his DNA is there. It's coming in, just like I predicted. And you better have an excuse or an explanation as to how it got there. But for a guy that didn't go to a whole lot of parties, didn't know anybody there in that house, somebody's got some explaining to do, right? Remember, little is on the tab here or on this side, it doesn't matter. That's where the DNA is, the little tab, the little button in the Bryan Kohberger matter. So now it seems as though the defense has given up on their whole IgG material, right? Not going to go into it. How they invaded the privacy, how they didn't follow procedures. It's all good for motions hearings. Denied. Now move on. This trial may be rather short. We may be talking a couple of weeks. I don't know. We'll see, I guess. We'll see. But I think it's significant that the defense, remember, they spent a lot of time fighting the investigative genetic genealogy and to then just want to give it up. I mean, part of the reason you have the motions hearing is, okay, you want to do it, but should you try to bring it up? Should you try to get it in front of the jury? I mean, you spent a whole lot of time, money, and effort trying to keep that IgG out. You think you'd want to have some sort of explanation as to why it can't be accurate. Well, it's kind of like the prosecution has said. It doesn't matter, Judge. We used it as basically a tip. We ran the known DNA sample, or the sample from the swab here on the button. We ran it through CODIS. Nothing came up. Not surprising, since Bryan Kohberger didn't have any criminal history. So they sent it off to the investigative genetic genealogy people, right? And they go to the FBI, and the FBI says, well, we'll try a couple of these, and we'll even send it to a couple, this profile, to see if it matches these others, even though we're not really supposed to. So it's just a policy, not that big a deal, right? And they come back and they say, hey, you may want to look at this Bryan Kohberger guy. And then they're like, hey, look at that. Wouldn't you know it? That Bryan Kohberger guy drives this little white, was it Hyundai car? Very similar to the one that we have going by the house or down the street through some video surveillance. Okay, let's start doing some warrants on that. Hey, let's arrest this guy. We think we got enough to arrest this guy. Then we're going to get his DNA. We're going to get a known sample from his DNA, right? They do the little buccal swab. They literally, I just had this done, last week on a client. Sitting there in court, got our case called up. And the DA is like, Your Honor, we would like to get more information as it relates to this case. So we're seeking a motion to get, Mr. Reich's client's DNA. And the problem is, whether it's Rule 16 or 41-1, if the judge finds that there's probable cause to take that DNA sample, guess what? They get it. And so the case was done. Guess what? There's the investigator from the DA's office. He shows up with his little kit. It's literally four Q-tips, like long Q-tips, right? He pulls them out, hands them to the client. Client rubs them on the inside of his mouth, literally, just like that. Sticks them back in the little thing. They break off the top. They fold it over. They seal it up, and they're going to send it off to the DNA lab. Boom. So that's what they did with Bryan Kohberger. So they get the sample from the K-bar button. Then they get the known sample, and they can compare that known sample to the K-bar and say, bam, we got our guy. And then they start going through and, getting all the warrants based upon that. Hey, we believe, what's his shopping habits? Has he purchased a K-bar along the way? We'd sure like to know if he's purchased that K-bar. And of course, you can always tell where the bad evidence is coming from. It's called motions in limine. It's called motions to suppress. Do whatever you can. You literally sit there as a defense attorney, ladies and gentlemen, little defense attorney secret here. What evidence has to go away for this case to be triable for the defense? So if there's a bad statement, if there's bad physical evidence, bad video, can I make that evidence go away? If I can't make it go away, can I explain it away? Can I embrace it and say, by gosh, yes, my client's DNA is supposed to be there. He was there consensually. I would expect to find his DNA there. He was there all night. He was an invited guest, right? You have to be able to do that. Explain it away. Embrace the bad facts. How do you take, literally, sometimes we get on the big whiteboard, good facts, bad facts. And then we literally say, how do we move the bad facts and move them over to good facts on the board? And so that's what they ultimately have to do. Okay. But the defense has got some problems. And I've told you, you can go back to all these cases. As soon as we knew that there was DNA on this little button, I went out to the garage, found my bags that had all my military stuff, and I go and get my K-bar that I've had since the end of summer of '88 when I graduated from boot camp. Still have this bad boy. Why? Because Marines don't lose their gear. They're responsible for their gear, right? So I don't know how many years later is this. I still have this thing. And allegedly, Bryan Kohberger couldn't manage to keep track of his for more than a few hours, apparently. He never would have been able to make it as Marine. You lose your gear, you're dead, right? That's what they teach you all the time. Hell, I have a pen that was given to me when I graduated from law school, for goodness sakes, ladies and gentlemen. It's a very nice pen. And I still have it because you keep track of your gear. And allegedly, Bryan Kohberger, giving him the presumption of innocence, but if that was him, lost his gear, left the sheath underneath the body, right? And your DNA just happens to be there. So when all that news broke, and you can go back and look, okay? You can go back and look. My chair somehow got jammed underneath the table here. Jeez. Anyway, he leaves this knife sheath there with his DNA, and go back and look at the old videos. I said, hey, I'm a defense guy. Nothing would give me greater satisfaction, as a defense attorney, for your fellow brethren defense attorney, to have a big win, walk somebody on a case like that, right? And I said, only way Bryan Kohberger is going to get out of this little predicament that he has managed to place himself into is the fact that he needs to be able to explain away how the DNA got there. And so far, in all the motions in limine, no explanation. I mean, they tried to say that he had some expectation of privacy as it related to the genealogical databases that these people had. No. He never actually claimed a possessory interest in, and the court noted this, he never articulated that he wanted the knife sheath suppressed as somehow it was obtained illegally. Frivolous motion. But then you have to admit, if you're saying that you want something suppressed, you're having to say that the item seized was illegally obtained. And they tried to say that, but it was abandoned. And he never said it was his, because he tried to say, I don't know, obviously. I don't know. Maybe the defense has got something, maybe like we talked about the other day on the Karen Reed stuff, right? The whole police conspiracy thing usually doesn't work out too well at trial. Okay. Because contrary to popular belief, nobody's going to get up and admit that they committed a crime on the stand, at least not knowingly. You may be able to argue it, the real reasonable inferences drawn from the evidence or the lack thereof. But when you're trying to say the police engaged in a conspiracy, unless you have a police officer that's been charged with some sort of illegal conduct, and he probably isn't testifying, there's no way that the cops are going to admit to that. And not to digress too much on the Karen Reed case, but their case has fallen apart. I've always said that. The defense has one shot. It's called the first trial. If it mistries because of, somebody saying something in court, or the jury can't reach a decision, it never gets better for the defense the second time around. I swear, ladies and gentlemen, never, ever does. And it's not getting better for Karen Reed. So, something to think about. You got to be able to explain it away. Okay? Those bad facts. Here, Bryan Kohberger has bad facts. He's got that knife sheath. I've seen nothing so far, whether it's through motions or filings or any other time, that try to explain away how that knife sheath got there. And my guess is, and we don't know, so I say when I say I guess, I'm saying I'm taking an educated guess that in one of those little purchase things from Amazon, something is going to come up with a very sharp item in it. I'm guessing here. I have no inside information, but they were trying to the defense was trying to keep that out. Whatever he purchased on Amazon, it's not good. Otherwise, they would not be trying to keep it out of the jury's preference. So just think about that, ladies and gentlemen. Think about that. What is he going to do? What is he going to do? Now, I have said this all along. The defense is going to be doing what they're doing. But I would say do not be surprised if right before trial, there may be some sort of plea bargain to avoid the death penalty. That would be my guess. That would be what I think is going to take place. The defense was pretty cocky early on in the Kohberger case. And don't get me wrong, Kohberger's got some very good attorneys. All right. Very good attorneys. Miss Taylor, she can kind of sweep the floor with the attorneys from the prosecution side. She's good. But eventually the facts keep coming out. And the facts keep pointing to Bryan Kohberger. And the alibi. I mean, I swear to God, if I was on trial for a quadruple murder and I said I didn't do it, let me explain where I was. I would be yelling it from the mountaintops. I was out watching the stars. And at this particular time and location, when they said that the murder occurred, I couldn't have done it because I was on this hilltop, but I didn't turn my phone off. I would have had, something to put me there. Right now, I haven't seen anything but on the search of the car, but oftentimes they have GPS stuff. I don't know if that particular model of Hyundai did, but a lot of cars, I mean, it's amazing the amount of information they can get from the cars. They can certainly get it from his phone. They've dumped his phone, and all they can come up is, well, we believe sometime during the hours where these murders were committed, we believe that Bryan Kohberger was out driving his car. And of course, they're going to have, I think we saw experts about what the weather looked like that night, whether it was overcast or whatever. But normally when I'm looking at the stars, yes, I'd want to go someplace where there's not a whole lot of light for sure. And, maybe if I was an astronomy dude, little bug out there, maybe I'd want to take a telescope to show my enthusiasm for looking at the stars. And, maybe I'd even be able to say, yeah, I was there because I took a picture of, through the lens of the telescope. And I did that. Perhaps I would even come up with a few friends of mine to say, oh yeah, Scott always goes to his favorite spot to watch the stars whenever it's clear. And I know because I've been there with him. In fact, on that particular night, he was going to invite me to go with him, or he did invite me, but I couldn't go. But he said, all right, well, I'm going to go anyway. I'll take good pictures with you. I would come up with any way possible to say I couldn't have been at that crime scene. Now, obviously, the prosecution does not want to prosecute an innocent man. I think that would be a prosecution, even the judge's worst nightmare, that an innocent man was prosecuted if it's the wrong guy. Nobody would want that. Now, obviously, there's a little bit of DNA, right? A little unknown DNA, a little bit on the railing, a little bit on a glove found outside. Okay. But nothing points to anybody that they can identify. So maybe somebody else was there. But guess what? Those other people aren't charged. What is Bryan Kohberger going to say? I just happened to be there with a couple of other people, but I didn't kill anybody. Is it like the Lori Vallow defense coming in? Sure, there was a conspiracy, but I didn't do it. Mere presence. Just because I happened to be there at the crime scene does not mean that I did anything wrong. Mere presence. It's an actual jury instruction. And then, so if I had an alibi that was valid, and let me tell you, I've had clients that have had alibis, and you know what happens? We get that case dismissed immediately because it is a provable, verifiable alibi that the client could not have done it because he was at a different location. How many times have I ever had an alibi they go to trial win? I don't know if you can tell, that's zero. Because somebody had an alibi. Somebody always comes with the alibi like month 5, into speedy trial, 1 month before trial. And then you're like, okay, you're telling me this, you were with this person. You just haven't been able to find this person, right? Now, technically, the defendant, if they're going to take the stand themselves, does not have to give notice of that alibi defense. Although you would think if it was going to vindicate you, you would turn it over, right? But they're going to go, the other side's going to go check it out. The prosecution's going to go check out that alibi and see if it's viable. And usually my experience is it's some guy's girlfriend that he met. Usually, you find out while he was in custody. And, the old conversations on the jail calls are like, hey, babe, I was with you that night. Oh, yeah, you were with me, babe. Yeah. Oh, okay, but you didn't know each other and there's no communication between. Something usually falls apart. So I think the alibi is going to be a problem. The DNA is going to be a problem. The video is going to be a problem. Let the jury, it's a question of fact for the jury to decide, was that him in his car? Is he the one that did this? And now they're basically abandoning the whole, my client's DNA was obtained illegally. Now, obviously, that's not an issue for the jury to decide. The judges ruled. Judges rule on legal issues and motions. The jury decides questions of fact. So I can understand why the defense has abandoned it, but you think maybe they try to make a big deal out of it. And they're like, yeah, no, we're not going to go there. Maybe they're going with, let's fly under the radar with the whole DNA thing because we don't want to highlight it. We have other issues to focus upon. Like I was out driving around. I guarantee you, in the time that they've had, they know exactly where that car was just about every second that they can possibly monitor it. And ladies and gentlemen, you'd be surprised. And I wasn't aware. I mean, I was generally aware of this, that the police can, generally follow. There's cameras and monitors and things of that nature at various places where they can always look for your car. But I didn't realize how, I don't know if it's good or bad, scary a little bit, because I mean, it's totally like, George Orwell's 1984. They know everything that you're doing. Not that they don't already when you have your phone, etc. Right? But so I have this client, they get pulled over, western part of the state. The cop says, these two gentlemen look suspicious to me. So he goes to his computer and, rat-a-tat-tat-tat-tat on the computer and says, wow, I plugged in that license plate. And do you know what they told me about that license plate? When I plugged that license plate into the computer, it tracked that car's entire movement from California, Southern California, to the state of Colorado. And the officer used that as reasonable suspicion to pull the car over and say, well, it's rather suspicious that somebody drove all night from California to Colorado. I don't know, it's like 12 hours or so. I mean, is it suspicious? Do people drive at night all the time? Sure they do. But they try to say, oh, I was suspicious. Now, of course, they found lots of things in the trunk of the car. But fortunately, my client had the best attorney ever. Case dismissed. But the point is, the point is that they literally, with a few strokes on a keyboard, they could track you everywhere you went across country. So do you think that they have all that information on Bryan Kohberger, even if he's driving through the little valleys and what have you there in Idaho and into Pullman, Washington? Oh, I bet you they do. I bet you they do. No doubt in my mind. No doubt in my mind. Obviously, we know they tracked him all the way across country. Now, you can tell me, right? I mean, they say they didn't know that Bryan Kohberger was the suspect. But what are the odds? What are the odds, right? They just happened to pull him over a couple of times just to get his ID, check it out. I mean, color me suspicious, okay? I just think that was just a little too coincidental, right? It's like when you get the client that just leaves a multi-kilo drug deal and he says, yeah, as soon as I was there, man, I got pulled over. It was so weird. Yeah, it wasn't weird at all. It was totally planned. And they did that to pull you over to see who you were, to get your identification. And they sent you on your way, didn't they? Yes, they did. You will be arrested probably within the next 4 months. Okay? Just like what happened to Bryan Kohberger. Now, I know they said there wasn't anything going on, but my guess is they pulled him over. But there's nothing illegal about that because they said he was speeding, I think, or weaving lanes at one point. That's it. So the point being, ladies and gentlemen, there are no coincidences when it comes to criminal law and criminal investigations. They're usually 2 steps ahead of everybody. particularly once that has taken place. Now, I know some people say, well, no, Scott, they didn't know. They didn't get the IgG until they got the food. And I get it. I know. But they were looking. They were looking. We maybe just don't know about it yet, but they were looking at that car. Just a hunch based upon a little bit of experience. And I think I have a rational basis in which to say how that came about, right? They said, hey, we got this white Hyundai. Okay, let's plug that in. Let's narrow it down. Maybe we can get a license plate on one of these other, tollways or, whatever. Then they use it and then they track you and then they know where it is. I know they say they didn't know who they were looking for. It's just mere coincidence that Bryan Kohberger got pulled over twice as he drove back to Pennsylvania with his father. What a coincidence. So anyway, yeah. I don't know. It's going to be interesting. I would say in my book, I still think there's about a 75% chance of the Kohberger trial going. I'd say there's maybe a 25% chance. And obviously a lot of the family members of victims in the Kohberger matter want the death penalty, particularly family of Miss Gonsalve. But as the family has now learned, this goes back to November of 2022. We're going to be almost 3 years in by the time we get to trial, right? August, just a few months shy of 3 years. With a guilty plea, there are no appeals. With a guilty plea, it's over. With a guilty plea, you'll never get a letter saying somebody's going to get out. There's not going to be, hey, they filed a post-conviction relief motion, and this thing is going to start all over again. Oh, the appellate court said maybe there was an issue and the defense is entitled to a new trial, and you have to go through all that hell again. I get it. The man killed 4 people, allegedly. And if he did, I think 4 people certainly gets you up there, for contention for the death penalty, no doubt. But sometimes you have to look at it in the sense of if there is a guilty plea, it is over. It's done. Like I said, there's no call from the district attorney's office 10 years later saying, guess what? The Court of Appeals or the Supreme Court said he gets a new trial. In 15 years, hey, there's post-conviction relief going on. We got to go through this all over again. And then all the appeals for that. That is why. And this is why, and I'm sure I will not have people in the defense bar like this. And obviously some people are opposed to the death penalty. Some people are for it. But I'm telling you, it is a tool for the prosecutors. It is a tool for the prosecutors. Because sometimes things get very real when they say, hey, we're going to kill your client. We're going to do everything we can to kill your client because, well, he deserves to die. And that client may say, well, I'd rather, even if it's in prison, I'd still rather be around to enjoy it. Maybe I got kids, maybe I can, I'll never see him again. At least not in a prison environment, but at least I get to see him. And that may be significant to them. I don't know. I'd say probably 75% chance this trial goes to trial. 25% chance there's some sort of plea bargain. But, and the reason why I think that there would be some sort of plea bargain is the finality of it. It has to come to an end. And that's one of the things that I like about, criminal cases. I always said it was so easy, but then you start doing more and more complex cases and more severe punishment. You've realized that the stuff never ends, right? I mean, I think I told y'all, I had to go and testify on a case on a post-conviction matter that I tried like 15 years ago, because it never ends. And so, it's finality, right? Prosecutors love finality. How do you get finality? You get it through guilty pleas. Trial, you may win, but you're going to be talking appeals for the next 5 to 7 years, on a death penalty case for the next 30 years, and it never ends. And I get it. If somebody killed my child, I would probably demand the death penalty as well, unless I wanted the end. And I didn't want him to get the notoriety, the trial for him to, get to dress up every day, because if he loses, he's never going to wear that suit ever again. Sometimes it's don't give the guy the satisfaction. I was going to think of another word. Sometimes you say don't give the prick the satisfaction, right? And when you go to trial, you give them the satisfaction. And I get it. The family's got to be on board. The prosecutor's got to be on board. But sometimes finality is the way to go. And remember, it's ultimately up to the prosecution. In most states, they have what they refer to as Victims' Rights Acts. And under the Victims' Rights Act, the victims, relatives, have a right to be notified of the proceedings. They have a right to be consulted with. Now, they don't have veto power over everything, but they can be consulted with, and their opinions should be considered. And obviously, the district attorney may have decided, hey, I'm going to give this family's opinion a lot of weight and consideration. And therefore, if they want the death penalty, by God, we're going for it. Now, the DA could say, we're not going to do it. I'll let your position be known to the court. But I think a guilty plea, and this is the one problem that I had in the Chris Watts case, and we talked about it and we got the transcript of it. A good old-fashioned guilty plea, in my humble opinion, should always include the defendant having to say, what did you do? Tell me in your own words, what did you do? So that there is a factual basis for the plea. Then you don't have to deal with the crap of somebody saying, oh, I just pled guilty to get out of jail. I want to withdraw my guilty plea before sentencing because my attorney tricked me, or something like that. Nonsense that comes up all the time in court. It's one thing called buyer's remorse. And in the Chris Watts case, the judge said, how do you plead guilty, 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 right? But he should have had, the judge should have had Chris Watts say, Mr. Watts, tell me in your own words what you did. Oh, I just happened to kill my wife and 2 kids and unborn child. Okay. Is that what happened? Is that the truth? Yes. Right? But the judge didn't do that. And so now there's still those doubters out there that say, oh, he didn't do it. There's still people out there still trying to get clicks on Chris Watts and his innocence. But if the judge had just asked him, tell me what you did, right? We saw it this morning in the Menendez case. The DA in the Menendez case said, no, I'm not agreeing to let these guys out. They've lied over the last 35 years. They've been, deceptive as it relates to what the facts are. And they need to admit that they killed their parents. And only then will we have a conversation about some sort of clemency. Seems to make sense, right? Kind of like what they say. Admission of guilt is the first step to rehabilitation. Judge, I did wrong. I'm going to make sure that doesn't happen again. But if you're just pleading guilty to get this over with, we've all heard it before. So anyway, if there is, and I'm not saying there is, I'm not saying, I'd say there's 75% chance of going to trial, 25% chance of a guilty plea. But if there's going to be a guilty plea, you get finality. And on top of that, you have the defendant say in his own words what he did and why. So that takes care of everything. All the conspiracy people who say, oh, no, he must have pled guilty or something along those lines. He's innocent. Have the defendant say in your own words. And I've had judges, particularly in federal court, they still do this. Some state court judges, but not so much because they're so busy. They just want to get through the docket. But there was a judge in Denver. He was great. And he would say, tell me in your own words what you did. And you prepare your client to say, you have to admit to the elements of the offense. You know, I choked out the missus, Your Honor, and caused her to lose consciousness. And, well, that was wrong. That was wrong, right? And now it's just, do you stip to a factual basis? We waive a factual basis, Your Honor, saying we're pleading guilty just to get it over with, right? But the judge would say, if you don't tell me in your own words, I'm not accepting your guilty plea because I, as a judge, don't want to accept the guilty plea of a person who thinks that they are innocent. And if you're innocent, you obviously should not plead guilty to a crime you didn't commit, right? Particularly murder. I mean, we're not talking like you're getting a speeding ticket and they say, hey, we know you were speeding, but we're going to offer you that defective vehicle. Probably don't need, to tell me what you're doing. Well, I was speeding, Your Honor. I'm very thankful that I got this 2-point defective vehicle that won't go towards my insurance, right? Everybody's been there for that. Just pay the fine, send it in. That's the kind of thing where, it's okay to plead guilty to something you didn't do. But we're talking about your liberty, your freedom. Yeah, not so much. All right. Can you believe it's already been an hour, ladies and gentlemen? Man, time flies when we're having fun. Oh, Victor says, hey, don't forget that firing squad is back up and running in Utah. Yeah, it is. They did it down South Carolina just the other day, Friday night. The guy that killed his girlfriend or tried to kill the girlfriend but killed her parents or roommates or something like that, like 30 some odd years ago. 30 years. But he took the firing squad instead. Took the firing squad as well. First time in first, was it 15 years or something? It was in the United States, been even longer in South Carolina because they brought it back because of the whole electric chair wasn't working so great, old Sparky. And then you got the lethal injection where the guy was a little freaked out about that. So he said, let's just do the shot in the heart. Isn't there a song about that? Shot in the heart and you're to blame. A bad name. Yeah. Anyway, it is what it is, ladies and gentlemen. All right. Hey, if you'd like to continue the conversation, there's a link down below. We're going to do our Patreon show. So for all our Patreon members, we are going to, we'll be there in a couple of minutes and we'll resume the conversation. And of course, we'll have the call-in line. We'll answer all of your questions since there's much fewer people there. And we'll do the Magic 8 Ball as well. So join us for the Patreon. Hope you enjoyed the show. Thanks for being here. Remember, the Constitution matters.